Hey everybody, Matt Johnston here, Matt the Lawyer, and we're back talking about social media policies. So before we get started, I do want to remind everybody, if you want to see more of these videos, be sure you click the subscribe button, which is either here or here. I just upload the video to YouTube. I don't know exactly where they place things, but I think it's in one of those two spots. Anyway, we're talking about social media policies. We're going to be doing a series of videos on social media policies. And this is one of those employee handbook type policies that are difficult to draft and difficult to enforce and difficult to understand. Part of the difficulty is the fact that there are competing interests at play. There are legal interests, there's employee interests, there's employer interests, and it's a very difficult balance to achieve. So let's talk about some of the legal things that are implied or implicated when we start talking about social media policies. The first of those is the anti-discrimination, anti-harassment statutes under Title VII of the United States Code. Title VII is the laws that are enforced by the Equal Employment Opportunity Commission, the EEOC. Technically, Title VII doesn't apply to employers with fewer than 15 employees, but most states have a law that sort of supplements, or doesn't supplement, it's the exact same law that applies to all employers. You just may be exempt from certain statutory penalties and damages, but you still can't discriminate against employees, you can't harass employees, and you can't allow such discrimination or harassment to take place. So social media policy is one way that you can help enforce your other anti-harassment and anti-discrimination provisions of your employee handbook and employment policies. The next issue is the National Labor Relations Act, particularly Section 7 of that act. The National Labor Relations Act, Section 7, says employees have a right to publicly and privately criticize management and to discuss the terms and conditions of their employment. The private and public use of social media is one way in which employees can criticize management. The interesting fact is that sometimes courts have to balance which one is more important, the National Labor Relations Act or the Title VII. There have been cases in which employees have used extremely derogatory language, basically racist language or discriminatory language directed at management, and have been protected from EEOC implications of it because they were discussing the terms and conditions of their employment under Section 7. So it is possible for the two competing legal interests to create something of a problem. Leaving aside simple legalities, we also have some interesting dynamics between the employer and the employees. Now, me personally, I'm a big free speech guy. I'm a big believer in the First Amendment. I believe that people should be able to say whatever they want. But just because you have the freedom of speech does not mean you have the freedom from the consequences of that speech. So an employee who makes discriminatory, racist, harassing, threatening posts about their coworkers are creating something of a hostile work environment in their workplace, and an employer has the right to regulate that. They have a duty to ensure a non-hostile workplace. So an employee who is making on private social media, making comments or statements that create a hostile workplace in the hostile work environment in the workplace, those employees are subject to discipline. So an employee may have a right to say what they want to say. They may certainly be protected by from governmental action for what they say. But unless the employer is a government agency, they may not be entitled to that same First Amendment protection that I tend to hold so dear. An employer, as I said before, they have an obligation to maintain a non-hostile workplace to prevent discrimination against employees and against vendors and other folks. But the employer also has a reputational matter to protect. They have a reputation within the community, a reputation within the marketplace to protect. And sometimes employee actions may damage that reputation, and an employer should be able to manage that. Now, sometimes an employee will make a statement that is not really about the employer, or is not about the employer at all, not about the employees at all, but because the community knows that that person is employed by a certain business, they may infer that that business endorses those views, rightly or wrongly, and usually wrongly, people will make that inference, but it does create a problem for the employer. And it's a very, very tricky sort of situation. So when we're crafting a social media policy, we have all of these competing interests that have to be balanced. And if you're an employer, you're going to want to make sure you create a social media policy that is, one, legal under both the National Labor Relations Act and the EEOC provisions, and you're going to want to make sure that you are balancing employee privacy with employer concerns, such as a non-hostile workplace and to protect the employer's reputation. So when you are crafting a social media policy, please, please, please consult with an attorney. How you doing? Matt the lawyer. But also make sure that you are doing so in a way that complies with both federal and state law regarding social media and communications. In future episodes, we're going to talk a little bit more about some of the language that you want to make sure you include in a social media policy, as well as what to do when you are faced with an issue related to social media. In the meantime, please don't forget to subscribe and check out our other content at mattthelawyer.com. That's MATT, thelawyer.com. And I will look forward to seeing you all soon. Bye-bye.